All right, sir, you Jay Stovall?
Yes, Your Honor.
And this is cause number 25 DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response, or a reply to that motion, and we're here today on that. I've done obviously some of my own research as well.
Filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second. I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course. Not pay attention.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. So
So the new statute is what?
it reads almost identical. It's
13.
13A.203.
Thank you. Okay. Getting there. Just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, it's violation of a protective order, correct?
it has to be multiple to be a felony. And that's what gets us to 7.2, I believe.
7.2 is repeated violation of certain court orders or conditions. 7.1 is violation of a protective order.
Right. I think they may have kind of pled it as hybrid, but they're talking about 0.2.
I would concede and agree that it should be 02, Judge.
Okay, so it says 0.2. That's correct then. All right. Okay. So with regard then to the new 13A.203, this is not a protective order.
It is a protective order,
But
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I
didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
But that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A.203 appears to be specifically on point. So what's the state's position with regard to that? Because it does, it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to the venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says, with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the an appellate court out of Austin, 1991, that's cited in my reply. It says, with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructive for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop somewhere in another part of the state, or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said I think are incorrect. First and foremost, the case that he's citing is from 1993. It is pre-social media. It's almost pre-cell phones. The case that he cites, too, if you actually read the facts of the case, the person was found guilty of a variety of different harassing communications.
Let's go to what I've looked up and what I've found, so I tend to agree. I mean, the Article 13A.203 does not say that it's where the defendant is. It says where the offense is committed.
Right.
And so the research to me is around offense being committed, what that means, not where he is, where she is. It doesn't say either of those things. So I don't think there's an automatic argument that it has to be where he is. There is Solis v. State, which is a 2003 case, specifically says venues proper if there's substantial contacts with the prosecuting county that has some relationship either to the defendant, his conduct, his victim, or the fruits of his crime. There's many cases that also say the same thing. There is that this is actually a Torres case. The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say, we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that, though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
but
so
if it can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
May then I be heard just on one other issue?
Yes, sir.
Mr. Coleman raised. So he said that would render an absurd result if we followed the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. Here's why. What it would allow any complainant to do is go to a really favorable